Pardon to
Against the
mention,
conviction, my lord. Appellant already custody more than 8 years, my lord.
my 8 years in custody, ma'am. And one is
more than 10 years.
Division bench matter, no?
yes, no, division bench. One is 12 years in custody, ma'am.
Please give it.
My lord, in my case, it is 11 years they are in custody for bail.
10 years.
Please give it.
I want to make a mention, my lords. Item 2 in today's list. My learned senior Mr. S.S. Rao is out of station. Can it be taken up?
Item number 2 means
Division bench. Second item.
now just let us see that what order has been passed to, because
Lordship is directed to
just
Yeah, my
please
lords.
wait for a moment. So, Mr. Who is to argue this matter on behalf of the Central Government Council? D.R. Bhokta was there.
Well, I am there. I am in peace.
Mr. Bhokta, okay. You said that you have already
served, my lord.
saw the
I have already solved the.
the
Today I will also-
those settlement revision case numbers that has been given. Okay.
So the records are called for last occasion.
See, my lords.
I
So-
submit before court today.
Hmm?
I'll also submit the
Hmm.
records in court today.
Okay. So give the settlement distribution. So we are calling for the reports. You have already called that one. We asked him to mention the yes, this is in connection with this settlement. No. Yes, that reason have it before petition. Supervisor Friday. Okay. So we are keeping a Friday, Chutti is coming Friday. If Friday, 17th of 17th. 17th we are keeping. All right. Learned Council for the state submitted that as per the order dated 12/4/2024, after making hard copies of the settlement revision case number so and so, so and so, the same has been supplied to the Learned Council for the petitioner. You are the associate of Mr. S.S. Rao, Senior Advocate, also accepted that the records have been received by him, by Senior. The Land Council for the state further submits that during course of the day, you'll file you'll submit the records of the aforesaid cases.
Also, copy served to the central government.
As a copy also served on the Central Government Council. Mr. D.R. Bhoktal and Central Government is present through virtual mode. It is further submitted on behalf of Mr. S.S. Rao, Senior Advocate, that he is not available today, and the matter may be taken up on some other day. On consensus of all the parties, put up this matter on 17th May 2024. Mr. Gupta, it will be taken up on 17th.
17.
Published.
Published.
Supplemental list, item number 1.
The persons are present. Advocate, please show us.
Kindly unmute, sir.
ठीक अच्छे से आपणकर जो दरखास्तटी दिया रिकॉल करिया पई तार सुनानी हबो आपण लर्निंग काउंसिल आपण जहाँ से मन पचारिबे तांग बुझी कहबे हला तापरे केस यस
I have filed an application under 391 services.
what is that application that IN number is
294 I have filed my today's number. And in the meantime, the state has special.
तेरा बाहर पर 1036 of 2024
Yes,
right
private criminal appeal, my lord.
right obviously 1036 of 2024 and Mr. Das, we gave you an opportunity to file any objection if you want. You have already filed. Okay.
And also my lord is whereabout of the
That lady is available?
yes, available in he is staying at Gajpati district, my lord.
Okay.
I have obtained the address and the
No, it's, we just want available
Yes.
or not because
yeah.
so-
In meantime, he is married.
you want to recall that
PW1.
PW1 for putting the questions
Which she has already deposed before the my lord judge that the principal magistrate.
and what are those questions? Dekhi
My
sir,
lord, I have
get us.
given the details. In
Now,
the court.
first tell us few dates
My lord,
in this
my lord, I come with that.
PW1.
My lord, she was examined
He was examined on that
And-
your case, this case in for the first time on what date?
31st July 2017.
31st July 2017.
In the first case, my lord, remember
Ah,
that
right.
Guntur.
That was
That is city
that
case.
was remanded, na?
No, my lord.
Huh?
Two trial has been made. First before the additional session judge Guntur, thereafter before the sessions judge Raigada.
No. Please be clear. This lady, the eyewitness PW1, was examined for the first time in which case?
In city case number 7 of 2017.
Out of which this death reference arises?
No. Thereafter, what has happened like this, my lord.
Just a minute.
Initially, all the total number of accused is 10. One is a CCL, remaining 9, who are before my lord as a appellant. All those persons, 9 persons, they have been first committed to the Court of Sessions and they have faced the trial before the Court of Additional Sessions Judge Gunpur by its city case number 7 of 2017.
Just
My lord.
city case number
7
of
2017.
okay.
Wherein in due process, this PW1, Milita Sabat, was examined on 31st July 2017, 31/7/2017,
Okay.
as PW1.
Right. And her cross-examination was also over
End of
that
the
day. Okay.
And everything was over, my lord. Thereafter, all the 9 persons were convicted as and sentenced for death penalty. They preferred appeal before the Honorable Court. And while hearing, the Honorable Court has said, because of the fact that the 364, 365, they have not been charged, my lord, charged. So accordingly, they have been directed to be charged with that offence and for a fresh trial. And but the learned court below.
Just a minute. Let us see that operative part of that particular order, which in this previous, you said death reference case. Where is that available?
That is the death reference case, my lord. It is quoted, my lord. The order and pays, my lord.
Judgment.
In the judgment, my lord.
As a judgment or operative
My
part.
lord.
Acha, is that DSREF 1 of 2018? Maybe that.
No. It was 8 of 2020, the trial number.
No. Death
1 by 2018.
Yes. First one, my lord.
Okay.
Page 162, my lord.
DSREF 1 of 2018.
18.
Show the judgment which was passed in that case.
Page 162, my lord.
Of the paper book.
Paper book.
अच्छा ये first paper book टा देखी 1 केते क्वेश्चन सेटा flag mark
162. Back side.
Internal page 4 of the judgment.
This is the judgment of this court That has
Earlier,
been
earlier.
quoted here. Right.
Regards being had to the above law and in order to consent fair trial, we are of the considered view that learned additional session judge has committed an error in convicting the accused persons under section 365 of the IPC without framing charge in sessions trial. Offense under section 365 of the IPC provide the kidnapping or abducting with intent to cause that person to be secretly and wrongfully confined. This offense under section 365 of the IPC is not a minor offense to section 302 of the IPC. The ingredients of this offense are not ingredient of the offense of murder. Offense of abducting is not a cognate offense to murder. What follows from the above reasoning is that a failure of justice has been occasioned due to such conviction under section 365 of the IPC without charge. It is not a curable irregularity, and a lower court should have resorted to section 216 CRPC. For the availability of material on record, including the police report, learned additional session judge should have framed charge under section 364 and 365 of the IPC. On opinion, our opinion is perused by the materials on record that dead body of 3 deceased persons could not be recovered and DNA profile from the charred bones could not be conducted. We are concisely restrained to make any observation on the merit of the matter, including the apprehension of evidence made in the impugned judgment under reference as grave error has been committed is not framing charge and thereby failure of justice has been occasioned. We feel it just and proper for the interest of justice to direct further inquiry under section 367 CRPC. We are constrained by the above analysis to set aside the conviction and sentence passed in the impugned judgment dated 11/4/2018 on stroke 13/4/2018 by the learned additional session judge Gunpur in criminal trial number such and such. In the result, the matter is remanded to the trial court with a direction to add charge for the offence of 364 and 365 of the IPC and to proceed keeping in view the provision of section 217 CRPC. And a trial court shall ensure the completion of trial within 6 months from the date of receipt of copy of this order. Accordingly, death reference is answered and jail criminal appeal is disposed of.
Okay. Thereafter, charge was framed, that additional charge was framed, and then PW1 was recalled, right? So when she was examined on recall,
Yes. She was examined because in the meantime the case has been transferred to the Court of Sessions Judge that Raigada, wherein she was examined on 2/3/2020.
Just a minute, 2/3/2020
in city case number 8 of 2020.
case number 8.
Session Judge Raigada.
Why it was taken up before another?
Because of the fact that in the meantime the apex court judgment has come wherein it says in mob lynching case only the Sessions Court can try. That's why the additional session doesn't have the jurisdiction.
So it was tried before Session Judge
Raigada. City case number 8 of 2020.
Okay. The statement which you want to confront, that was recorded in the trial of
yes. That's in GR case number 418 of 2016.
4 of 2018.
No, 4 no, 418 of 2016.
And there this PW1 examined
as PW12.
PW12 on what date?
14/11/2017. 14/11/2017. Principal Magistrate, Juvenile Justice Board, Raigada.
Okay. That means as on 2/3/2020, when the PW1 was recalled, this 14/11/2017 was the previous statement. Because law requires that only previous statement is to be confronted.
That's
so
all.
This
it's coming under.
Okay. So now this is one part. Second part is that what are those contradictions according to you that which are material?
I'm coming there.
And
I have also placed it before the court in questionnaire form. Madam, I turn to page 5 of my petition.
Where is that evidence copy of that PW12?
May I placement?
Just a minute. This PW1 रे evidence study on PW1 ର paper book ଦିଅନ୍ତୁ PW1 evidence of art from
ବଢେଇ ଦେଇଛି।
Okay, now give that statement PW12.
The deposit which was brought by this court Xerox ରୁ ଆସିଥିଲା ରାୟଗଡ଼ାରୁ ଆସିଥିଲା।
8ଟା ଚେଞ୍ଜ ଫ୍ଲାଗ କେତେ ମରା
Xerox ଗୁଡା ମୋଟା
You have filed certified copy.
No, madam. It was brought by this honorable court, but
Okay.
from direction of the honorable court, it has been. She was examined as PW12, madam.
No, you put those questions here.
Yes, yes.
Jota bahar kar.
While giving page 5 of my petition, madam.
Okay, by the way, just a minute. Mr. Das, what objection you have filed? Objection to the. No.
First is the report.
With reference to the subject cited above, honor that the above Melita Sava, who is Swanso, was married to Swanso. Acha, 8-year-old. Okay. Then, yes, what is your objection? Mr. Das, we want to know from you whether when this on remand, when PW1 was examined on 2/3/2020 of the same case, same trial, prior to that, this same witness has been examined in connection with the evidence, the trial of the co-accused, that is, which is juvenile. And that statement was recorded on 14/11/2017. Clear? Now please come to 145 of the evidence act.
No.
Please read it out.
Cross-examination as to previous statement in writing. A witness may be cross-examined as to previous statements made by him in writing or reduced into writing and relevant to matters in question without such writing being shown to him or being proved. But if it is intended to contradict him by the writing, his attention must, before the writing can be proved, he called to those parts of it which are to be used for the purpose of contradicting him.
So this section, in view of the decisions of Supreme Court, and this section does not only confine to 161 statement. If that witness is examined and it will be a previous statement relating to the same trial, same occurrence, okay? And one set of accused persons are examined first, and then subsequently another set of accused persons are examined. So this, if the same witness has given a statement earlier in the first trial, that can also be confronted to this, that can be used as previous statement. It does not necessarily mean, are you disputing about this proposition?
No.
You are not disputing, because that is the, so now if it is permissible, okay, what he says that at that stage the counsel should have put those contradictions to that witness. Inadvertently, it has not been done. Question is, now he has given the questions. So if we find that it is legally permissible, first one thing. Second, that in fact, these are the material questions which requires to be put. Ultimately, after it is brought to the notice, what answer will be given, why he has stated in a different manner, what would be the evidentiary value, that was to be considered.
At the time of hearing that.
Okay. But the question is, we are limiting that if it is permissible and the witness is available and it's a death reference case, whether in the interest of justice, if whether all or any of these questions which are relevant to be put, whether that can be permitted or not. That is the problem.
Right.
Now you can argue this matter.
My question is, my lord, they have filed an application under section 391, my lord. So on 391, my lord, let us, my lord, in 391 petition, they have mentioned that petition, my lord, come to para 4, my lord. Para 4 of their IA, my lord.
Yes.
That the petitioner humbly submit that as such, evidence of the informant before PM JGB Rayagada as PDOL 12 was not within their knowledge, and for the first time, they came to know about the same after the same was called for by this honorable court pursuant to the prayer of the appellants, and moreover, after verification of both the evidence, PDOL 1 and PDOL 2 of the
PDOL 1 and PDOL 12.
Of the same prosecution witness.
Right.
Of course, in different court, it was found that the entire evidence are materially contradictory and different to each other without even indicating the name or any other. That. My submission is that they have stated here that for the first time during the hearing of the case, they came to know about the aspect, my lord. Well, come to their appeal memo. Their appeal memo they have mentioned. There is para, my lord, 750, my lord. Page 13, my lord, para M. I have quoted it in my objection. Para M. May I plead?
Yes.
For that, as in the meantime, the CCL, namely Jamusavar, being faced the trial before the Children's Court, Raigada, has been acquitted, and although herein the PDOL 1 has made allegation against the appellants, but there in the court has presented a different story. Thus, the veracity of the evidence of PDOL 1 is not at all believable. Thus, the judgment deserves to be remarked. So, it was very well in their knowledge that there he has stated something else. But initial stage they didn't. What prevented them not to put on the questions before the to the PDOL 1 when he was examined on, my lord, dated 2/3/2020 when the matter was remanded and taken out. My lord, city case number 8 of 2018, my lord. So on that basis, my lord, I want to cite some judgment, my lord. I have given, my lord. Citation I have given, my lord. The first citation, my lord, 2001, 4 SCC 759. Para 2, my lord. Three paras I will place, my lord. A word of caution, however, ought to be introduced for guidance to it that this additional evidence cannot and ought not to be received in such a way so as to cause any prejudice to the accused. It is not the disguise for a retrial or to change the nature of the case against the accused. This court in the case of Rajeshwar Prasad Mishra versus State of West Bengal, in no uncertain terms, observed that the order must not ordinarily be made if the prosecution has had a fair opportunity or has not availed of it. This court was candid enough to record, however, that it is the concept of the justice which ought to prevail, and in the event the same uh, dictate exercise of power as conferred by the court. There ought not to be any hesitation in this regard. Para 3. Be it noted that no set of principle can be set forth for such an exercise of power under section 391, since the same is dependent upon the fact situation of the matters and having due regards to the concept of fair play of justice and well-being of the society. 4, my lord. Incidentally, section 391 forms an exception to the general rule that an appeal must be decided on the evidence which was before the trial court, and the power being an exception shall always have to be exercised with caution and circumspection so as to meet the end of justice. Be it noted further that the doctrine of finality of judicial proceeding does not stand annulled or affected in any way by the reason of exercise of power under section 391, since the same averts to the trial. No trial. It is not to fill up the lacuna, but to subserve the end of justice. Needless to record that on an analysis of the Civil Procedure Code, section 391 is thus akin to order 41 rules 27 of the Civil Procedure Code matter. So there they have mentioned that, so it should be, that should not be prior knowledge. Suppose they instantly came to know, but here, my lord, during the hearings they said that we came to know, but it was very aware.
The observation which has been made in paragraph 2 is very relevant.
My lord.
That it should not cause any prejudice to the accused.
Exactly, my lord.
That means the advantage, if by way of examination of any additional evidence
My lord.
which is taken, if it would be it put the accused in a disadvantaged position, would cause a prejudice to the accused, that is not to be permitted, that should not be allowed. Ordinarily, on the basis of whatever material are collected during trial, the appeal is to be decided. But there is an exception. They have stated that 391 purpose is for that.
But again, my lord, that should not be for the fill up the gap or the fill up the lacunas of the.
There is no question of fill up.
Because at that time, because if the opportunity has not been there, that when the matter is remanded to the trial court, again, there is an opportunity of to cross-examination or to put this question at the time, my lord.
Mr. Das, filling of the lacuna, suppose somebody is examined and cross-examined. Let us give an example. And in cross-examination, something is brought out in favor of the accused. Just to demolish that effect, suppose or when during stage of, let us say, argument, some lacunas of the prosecution is pointed out, and to patch up that lacuna, something is brought on record. So it is likely to, because they have already taken their defense, they have opened up the defense. So in such a case, there is likelihood of prejudice to the party, that means to the accused. Same thing also for the, so that is not that is not permissible.
Also, I am coming on that, my lord.
Yes.
Can I come to para 6, my lord?
Yeah.
Para 6, last part, my lord. Just back law dictionary.
Yeah.
That's second line, as noticed, my lord.
Para 5 to
Para 6.
para 6, yeah.
As noticed above, the purpose of introduction of section 399, 391.
Food portion.
My lord, last para, back of
Just a minute.
Blacks of Law Dictionary
Right.
defines, my lord. Last para. Shahara joda eji gote Italian
Page 762.
Notice.
Page 762.
As notice, my lord. Second line. As notice above, the purpose of introduction of section 391, earlier section 428 in the statute book has been for the purpose of making it available to the court, not to fill up any gap in the prosecution case, but to observe that the concept of justice does not suffer. The High Court itself record to rectify the irregularity. The issue, therefore, is whether this rectification by an additional evidence is a mere irregularity or goes to the root of the issue and instead of subserving the end of justice, the same runs counter to the concept of justice matter.
So, everything is stated that if you to subserve the ends of justice by adducing the additional evidence, then that can be taken, that is permissible. The appellate court should allow it. So that is the main purpose. The question is that even while exercising that, you should not allow the evidence in such additional evidence in such a way that it is to cause prejudice to any of the parties, maybe to the prosecution, maybe to the defense. Okay, because he has made of a case. Now you know that lacuna, let us say the pointed out in the judgment, or so that point now you, by way of adducing the additional evidence, let us say prosecution is trying to patch it off, that particular lacuna which is already there in the trial court, that the prosecution intend to patch it off at the stage of appellate court. Therefore, the prosecution wants to examine one witness. So that would be very damaging thing. That would cause prejudice. It is, I'm giving an example from the side of the accused. But if it is in the interest of justice, now, what is your, after all, what is your submission? That a chance was given. Let us say that whatever he has stated that it was not aware, it is a wrong statement. Let us go to that extent. Because in the appeal memo, he has himself mentioned that that particular witness being examined during the inquiry of that before the principal magistrate JJB has taken a different statement. Let us say that that was the omission on the part of the defense counsel who should have put those questions, but it has not been put. Now, before us to do justice, and that too in a death reference case, if those questions are allowed to be put, provided that they are material questions and in fact are available, then in what way prosecution will be prejudiced? He is your witness. He is right from the beginning. He is your witness. He has been examined till now thrice. Once in the trial when he has deposed as PW1. Second time in the case of the juvenile. Third time the matter went on remand. Again he was called, examined. Third time. So it is the same witness giving deposition in connection with the same case, same occurrence, but some statements given in the second one, that is in the juvenile trial, appears to be different. So if we allow those questions, if it is relevant at all, then in what way? Question is of prejudice, whether the prosecution will be prejudiced, and whether merely because there is some kind of laches on the part of the defense counsel, or he was not aware that these questions can be put. Let us say in that way, he was not aware that a previous statement can be put by exercising the power under section 311 CRPC, the witness can be recalled. So can that be the sole ground to deny justice to a person who has...
But in 2024, my lord, Supreme Court has recently passed a judgment, my lord. Our second judgment I have cited there. They pay para 9, my lord.
Yes.
Para 9. At the outset, we may note that the law is well settled by a catena of judgments rendered by this court that power to record additional evidence under section 391 CRPC should only be exercised when the party making such request was prevented from presenting the evidence in the trial despite due diligence being exercised, or that the facts given rise to such prayer came to light at the latter stage during pendency of the appeal, and that non-recording of such evidence may lead to failure of justice, my lord. My submission here, my lord. Here, my lord, the what they have not mentioned in their what steps they haven't taken, due diligence they haven't taken, what prevented them to put this question at the time of trial.
Mr. Das, can it not be, let us say, that existence of such a statement was not within the knowledge of the defense counsel when PW1 was again examined at the time of remand? After the conviction was confirmed, when the matter came to Mr. Manas Chand's chamber, he asked that whether in any trial that witness has been, because there was a juvenile after reading, they informed that yes, it has been examined. So he, let us say, came to know, and that is how the stand has been taken in the appeal memo, whether it is possible or not.
It is also possible in the not it is also possible that it was their knowledge, the evidence what is deposed in the juvenile justice court, my lord. But after that, knowing that they didn't take any step, took any step to cross examine at the time of the second time, my lord, when it was remanded, my lord.
Two things are there. Question is that
The parties are not same.
My lord.
Both the proceedings are different. One is before the JJB and the other is before the Sessions Court. So how to assume that it was well within the knowledge of the appellants regarding the statement of PW1 as examined as PW12 before the JJB?
Because they have mentioned in the appeal mode. I am on appeal mode. Because from that
acquittal ହେଇଛି ବୋଲି
no, acquittal nahi. Sir, ଜାଣିଛନ୍ତି PW1 ଯାହା ଏଠି
has been an inquiry
permission.
decision by the JJB acquittal of the
No, my lord. Kindly come to my lord that particular para, my lord.
If my lord permit,
I mentioned.
No, we have not at all heard you, Mr. We will hear you. Give you full opportunity.
So a particular line is there, my lord. Although the herein the PW1 has made allegation against the appellants, but therein the court has presented a different story. Thus, the veracity of the PW1 is not at all believable. Means they know what he has said.
that is one of the grounds in appeal memo.
Yes, my lord.
So let us.
That's why
we are going to the extent that let us say that the defense counsel was aware. Let us say that the defense counsel was aware.
Despite due diligence. Just mention
that is my lord. 138.
এই কেসরে কোন ହେଇଥିଲା এই ଯୋଉ କେସଟା ଆପଣ ଏକ୍ସାମ୍ପଲ ଦଉଛନ୍ତି
138 enact ରେ 138 enact ରେ ସରିଲା କନଭିକ୍ସନ ହେଲା ତାପରେ ସେ କହିଲା ଯେ ସେ ଯୋଉ ଚେକ୍ ଟା ମୁଁ କରିଛି ସେଟା ଫର୍ଜ ପ୍ରୋସେସ ହେଇଛି ମୁଁ ସିଗ୍ନେଚର ଟା ମୋର ନୁହଁ ସେଇଥିପାଇଁ ମୁଁ ଆଡିଶନାଲ ଏଭିଡେନ୍ସ ଦେବି that's why the court has said such.
So that's a different altogether. Mr. That observation was made factual scenario ku ଦେଖିବାକୁ ପଡିବ total ଆପଣ ସି ଯାହା କହୁଛନ୍ତି ଏଇଟା ଗୋଟେ ଏନ୍ଆଇ ଆକ୍ଟ କେସରେ
ପାରା 5 ଦେଖୁ
ଏନ୍ଆଇ ଆକ୍ଟ ରେ ଅଛି ସେଥିରେ ସେଟା ଆଣିଲେ କାହିଁକି ଏନ୍ଆଇ ଆକ୍ଟ ରେ
ଆପଣଙ୍କ ଗୋଟେ ଯୋଉ ରେସିଓଟା ଦିଆଯାଏ ସେଇଟାକୁ ସେଇ ଫ୍ୟାକ୍ଟ ଆଣ୍ଡ ସିଚୁଏସନ ଯଦି ଇକ୍ୱାଲ ଥିବ ଅଲମୋଷ୍ଟ ଆଇଡେଣ୍ଟିକାଲ ତାହେଲେ ସେ ରେସିଓଟା ଆପ୍ଲିକେବିଲିଟି ହେଇପାରିବ ଗୋଟେ କୋଉ ଫ୍ୟାକ୍ଚୁଆଲ କଣ୍ଟେକ୍ସଟରେ ଗୋଟେ ଅବଜରଭେସନ ଦିଆ ହେଇଥିବ ତାକୁ ଆପଣ ଆଉ ଗୋଟେ ଫ୍ୟାକ୍ଚୁଆଲ କଣ୍ଟେକ୍ସଟରେ ମାନେ ମେକାନିକାଲି ଇଟ୍ କ୍ୟାନଟ୍ ବି ୟୁଟିଲାଇଜ ଏଇ ସିଚୁଏସନ ଯଦି ସେମିତିଆ କେସ୍ ଯଦି ହେଇଥାନ୍ତା ଏମିତି ଗୋଟେ ହେଇଥାନ୍ତା ତାହେଲେ ଏମିତି ଅବଜରଭେସନ ହେଇଥିଲେ better would have been different. That is not a general observation.
My lord's own judgment is there, my lord. Yes. I've also cited, my lord, that is in Purnachandra Samal case, my lord, has passed in order. In that para 11, my lord, my lord is also pointed out.
Let us see.
Viewed, my lord.
Similar case, the Aguru gote trial heitila,
that's one.
dekhiya.
Para 11, madam. Law is well settled that whenever the appellate court thinks it necessary in the interest of justice to take additional evidence in order to arrive at a just decision of the case, or it feels that there would be failure of justice if the additional evidence is not taken, it has to record its madam.
11 है para 11.
Yes, please place it once again.
Madam, law is well settled that whenever the appellate court thinks it necessary in the interest of justice to take additional evidence in order to arrive at a just decision of the case, or it feels that there would be failure of justice if the additional evidence is not taken, it has to record its reasons and either take such evidence itself or direct to be taken by the lower court. The appellate court, however, should not exercise such power to fill up the gaps in the prosecution case, or if it feels that it would be prejudicial to the defense of the accused. If either of the parties had fair opportunity before the court below for adducing such evidence, and in spite of that they didn't avail the same, no such order for adducing additional evidence shall be provided to the parties by the appellate court unless the requirement of justice so demands.
Yes.
Same 130 in next case.
Again, it's a
Same
130.
principle, sir.
This is nothing.
It is similar to the judgment of the Supreme Court.
That is a recent.
How-
It was by my lord in 2017, but that was my lord in 2024 NI Act. But the principal,
Come to the first judgment, para 2, just read it out.
which one, my lord?
Para 2, the Supreme Court judgment.
First one, my lord. My lord.
Para 2, the middle. This court, in the case of Rajeshwar Prasad Mishra versus State of West Bengal, in no uncertain terms, observed that the order must not ordinarily be made if the prosecution has had a fair opportunity and has not availed of it.
My lord.
Next line is very important. This court was candid enough to record, however, that it is the concept of justice
My lord.
which ought to prevail, and in the event the same dictates exercise of power as conferred by the court, there ought not to be any hesitation in that regard.
My lord.
So even if the opportunity was there and it has not been availed of, then also in the interest of justice, the court has the power to exercise the
My lord.
discretion while entertaining application section 19.
If my lord-
Question is very simple. Question is,
If the
Mr.
justice
Yes,
so
Mr.
demand,
Patnaik,
judgments.
please use the mic because the clients are also there.
All the judgments I have gone through.
Yeah.
The basic question is the interest of justice,
Yes.
and that is a question
Param-
which your lordships will decide.
You know, exactly we are
Yes.
asking, it's a
All the cases,
death reference case. Let us say that there is some kind of latches on the,
Right.
we are going to that extent,
Yes.
on the, that it is legally permissible. That is why I
Yes. Yes.
asked,
Yes, ma'am.
asked the question whether it is legally permissible or not. He says it is legally permissible.
Yes.
Question is that whether he should have put this question to the witness because the statement is contradictory. Answer is also yes. That yes, he should have at that point of time should have put. Question is that if he has committed some, let us say it was on the latches, he could not confront it. Now we are hearing, we have got power. Can we deny
Yes,
it in the interest of justice or allow these few questions to be put?
Only thing, my lord, it is if it is bona fide, it is a my lord, it will be a factual decision of your lordships. What will the prejudice being caused by not examining or by examining? That is the
No, if it would have been a matter of different nature, because
Yes.
same occurrence ru dita trial aila, same witness dita stage re heichi. Jodi konosi statement emiti se second case re dela, jota ki completely
Yes, that is-
contradictory, ebong seitaku record ku asile the result would be otherwise.
My lord, that
Tale, in the interest of justice.
yes, my lord, there is nothing can stop
So
for
that
interest
Even,
of justice.
even assuming for the sake of argument
My
that
lord.
there was no diligence at all, the defense had
It
fair
is up
amount
to
of
your
opportunity
lordships,
to avail such an
even
opportunity.
appellate stage, my lord.
Yes, yes.
The appeal is a continuation of the trial also in some judgments like that. So at appellate stage also, my lord can use the for interest of justice that section has been given, and your lordship's judgments are all are what we argue that whether it will be abuse of process because
That is absolutely right.
that or
If
it
it is an
is
abuse
filed.
of process,
Oh yes,
it
yes,
should not be done.
yes,
If it is in interest of justice, it should
yes,
be done.
yes, yes,
Yes,
yes, madam.
So,
So
the
as per the judgments,
Yes,
what we have read it out now, even if there is no diligence, assume for the sake of
yes,
argument,
yes, yes,
even if there was a fair amount of opportunity for the defense to
yes,
recall a witness or adduce evidence
yes,
in terms of section 391 CRPC, which has not been availed of, then also in the interest of justice,
that
power
can
may
be.
be exercised.
Yes, it can be. Yeah,
It can be.
Yes, there is no doubt about it.
because even
Because such exercise of jurisdiction is not fitted by any limitation.
All the judgments we have gone through.
they have very well used that term in the interest of
It is justice.
Then
And
what are the evidence that
now
materially discrepant,
yes, that
so that it can be confronted to P.W. 12?
My humble submission, it was contended by the state that at the time of filing, although I have taken a ground, but I have failed to comply the same at the time of second cross examination. My humble submission, the P.W. one, she was examined on, my lord, but I have filed the appeal much after that. I have filed the appeal after about 1 year, 9 months thereafter. At the relevant time, there was no scope on my part to get all those documents and to put it before under 391. So this is the right time. During hearing of the appeal, I have brought it.
No, what they are pointing out
My,
that how if that was not within your knowledge, how you take
I'm coming to
that
that.
ground.
My humble submission, she was examined for the second time on my lord 2/3/2020.
Right.
I have preferred this appeal on 20/12/2021. 20/12/2021.
Just a minute.
My
Appeal kebe gala?
20/12/2021. And she was examined on 2/3/2020. So by the time she was examined, and by the time I filed the appeals matter, at the relevant time only I came to know. So at the relevant time, I don't have the other opportunity to file a petition because only at the time of hearing this 391 has the.
No, 391 petition at that stage, how could
you? There is one submission.
It is during the course of hearing,
and,
you can.
And there is one subsequent submission before my lord is that at the time when she was cross-examined, when she was brought for the second time and cross-examined to that only extent on 2/3/2020, my lord. At the relevant time, there is no scope on 391. Only the scope is 311.
Right, 311.
So because of the fact that I don't have any knowledge, so I have not filed the application of 311. That is my submission. So 391.
No question of 311 does not arise because the statute permits that if the alteration is there, then the opportunity is to be provided.
Right.
Exercising that power, the trial court called that witness.
My
because you intend to, prosecution did not intend to put any question in the chief examination, but you intend to cross-examine. Okay, so one witness was called. Thereafter, I think another witness was
PW11.
So those are the two witnesses. Rest of the witness you did not want to call for those witnesses.
PW1 was examined by the court. PW11 was examined only on our petition.
Right. So
216 to 17.
So PW1, it was not under section with the exercise of the power under section 311 CRPC. It was because the statute permits that if the charge is altered, then the opportunity is to be provided to the defense, if they want to examine, they can file petition,
ma-
call for any witness. Okay. So
So by humble submission, because of the fact that this information was not available to me when I have cross-examined on 3/9/2020, and this information I obtained only at the time of filing of the appeal. That's why I have made.
that is why I said that it might not be within the knowledge at that point
And
of
this
time.
391 can only be ballot exercised only at the time of hearing, not before that. So hearing has commenced. So
No,
that is my submission. And the other aspect, what my friend
now what we want that those questions which you have given,
yes, madam, take
how far
page,
those are
yes,
relevant,
page 5 of my
and
petition.
whether there is, because every minor omission here and there, that would not do. If there is any-
Yes, everything, each and every question will definitely change the fate of the appellant. If my lord kind enough to allow this,
yeah.
page 5 of my petition, my lord. It starts from may place it.
Data statements pattern or play
I did it.
ଆପଣଙ୍କର ସେ ଯୋଉ
evidence PDL 1
statement ୟାର କେତେ ଦିନ
ଗୋଟେ PDL 1 ଗୋଟେ
12 ନମ୍ବର ସେ କି ନା
12 ଆଜ୍ଞା 12
ହଁ ମେଲିତା ସାବର ରାଇଟ୍
ଆଜ୍ଞା my lord.
yes କଣ ଆପଣ ପ୍ରଥମ ପ୍ରଶ୍ନ କଣ
first question on 9/6/2020 I'm sorry 9/6/2016 I'm sorry.
no question would start from
you
while giving your evidence.
While giving your evidence as PW number 12 before the court of Lane PM JJB Raigada on 14/11/2017 in GR case number 418 of 2016, you have not deposed the following things in your evidence, my lord. First, on 9/6/2016, I'm sorry, you rushed to that spot and you cried after finding that your parent and sisters were tied up by these accused persons who were all present there.
କଣ ମାନେ କାନ୍ଦିବାଟା କହିନି
କାନ୍ଦିବାଟା ଆଜ୍ଞା ବାନ୍ଧିବାଟା ଆଜ୍ଞା
ବାନ୍ଧିବାଟା
କହୁଛି ଯେ ମୁଁ ଗଲି ଦୌଡ଼ିକି ଗଲି ସେଠି ସମସ୍ତେ ଜଣ ବନ୍ଧା ହେଇଥିଲେ ମ୍ୟାଡମ ସି ଦି ଏଭିଡେନ୍ସ ଅଫ PW 12 ମ୍ୟାଡମ
PW 12
ଆଜ୍ଞା ପାରା 2 ମ୍ୟାଡମ ବେଶୀ
ଆପଣ ପାଖରେ PW 12 ର ଏଭିଡେନ୍ସ ଅଛି ତ ମିଷ୍ଟର ଦା
ଆଜ୍ଞା ଦିଆଯାଇଛି ଆଜ୍ଞା ମ୍ୟାଡମ ପାରା 2 ମ୍ୟାଡମ
ଏପରା ଲେଖିଛନ୍ତି ପାରାଗ୍ରାଫ 2 ରେ
ଆଜ୍ଞା
when I reached at the spot they also tied me ଆଚ୍ଛା me
ସେଇଟା ଆଜ୍ଞା ପାରା 2 ଟା PW 12 ଦେଖନ୍ତୁ ମ୍ୟାଡମ
ହଁ ଏଠି ଅଛି ତ ତା ପୂର୍ବରୁ ଦେଖନ୍ତୁ ପ୍ଲିଜ one Damant Sabar of village informed me that some of the villagers had taken my parents and my elder sister to the cow shed of so and tied them there. When I reached at the spot, they also tied me in a wooden pole near me in the cow shed. कौन असुविधा होला कौन ता कहला contradiction
plus Malal is looking up to the evidence of PW 1.
No, we are looking at PW 12's evidence.
ଆଜ୍ଞା ପାରା 2
କହୁଛନ୍ତି
ପାରା 2
ହଁ
ପାରା 2 ମ୍ୟାଡମ
paragraph 2 ହଁ
on 9/6/2016 one Friday at about 7:30 p.m. evening when I came back to home after giving maize or something, I found my father sister missing. One Damanta Sabar of village informed me that some of the villagers had taken my parents and my elder sister to the cow shed of Giriyasalo and tied them there. When I reached the spot, they also tied me at the wooden pole near the inside cow shed.
ଏଇଟା ଅବିକା କହିଲା ସେ ଏକ ନମ୍ବର ସାକ୍ଷୀ ହିସାବରେ ହେଇକି କଣ କହିଥିଲା
ଏଥିରେ ସେ କହିଲା ଆଜ୍ଞା ସେଥିରେ
they are also tied up me in the stump and all of them were
ଆଚ୍ଛା ଏଇ ଯୋଉଟା କହିଥିଲା ସେ ନିଜେ ଦେଖିଲା
ଆଜ୍ଞା
ତାର ବାପା ଘରିକା ବନ୍ଧା ହେଇ ଅଛନ୍ତି ନାଇଁ ତ
ନାଇଁ ଅଛି
ସେ ଦମନ
ଦମନ
ସବର informed me
inform me
parents were tied up so I rushed to the spot I cried finding that they were tied up ଏଇ ଯୋଉ ଲାଇନ୍ ଟା ବୋଲ
see all the accused persons who were all present there ସେଇଟା ଆଜ୍ଞା
tied there
no accused persons ଆଜ୍ଞା my emphasis is on
all the accused persons were present there sure. Then next one
you have not two you have not deposed regarding assault by means of crowbar crowbar କଥା ଆଜ୍ଞା କହିନି ଆଜ୍ଞା specific madam see which she has said in para ଆଜ୍ଞା page 104 ର top ରେ madam see 104 ରେ other part ଅଛି lathi stick crowbar
କୋଉ paragraph କହୁଛ
ଆଜ୍ଞା page 104 ଆଜ୍ଞା
we are looking at
top first line ଆଜ୍ଞା PW first line PW 1 ର ନା Period 1 ର 104 ପୃଷ୍ଠା ଉପରେ କ୍ରୋବାର ଟା କହିଛି ଟିକେ
ଲାଠି ଷ୍ଟିକ୍ ଆଣ୍ଡ କ୍ରୋବାର
ଆଜ୍ଞା ସେଥିରେ ସେ କ୍ରୋବାର ଟା ନାହିଁ ମ୍ୟାଡ ମେସି
ଆଚ୍ଛା କ୍ରୋବାର ରେ assault ହେଇଥିଲା ବୋଲି ନାହିଁ
ନାହିଁ ଆଜ୍ଞା
ତାପରେ
ତାପରେ 3 ଟା you have not deposed that parents and sister witchcraft co-villagers as a consequence of which Biranti and Jamran of our village died ସେଥିରେ ବାପା କଥା କହୁଛି ଏଥିରେ ଭଉଣୀ କଥା ଏବଂ କଥା କହୁଥିଲା ସେଥିରେ କେବଳ କହିଲା father your sister and the mother 4 matter you have not deposed that accused persons continued to assault 3 of them till they lost respective consciousness ସେଥିରେ କେବଳ କହିଲା ବାପାକୁ ମାରିଲା ହେଲା ଭଉଣୀକୁ ପିଞ୍ଚ ହେଲା ଆଉ ମାନେ ମଦର କିଛି ନାହିଁ ବୋଲି ଏଥିରେ କହିଲା 3 ଜଣ ଯାକ 5th ରେ you have not deposed that at that time this is important at the time accused Dasanta brought pesticides meant for cotton crops in a bucket and administered the same by means of an injection syringe on different part of our sister body namely eye nose mouth chest and breast and you cried loudly and seeing that accused Bubuna came to you and threatened you by pointing a knife, saying that if you continue to cry, you'd meet the similar consequence. He then pointed injection syringe and stuffed in it on your neck.
ଏଗୁଡାକ PW12
କିଛି କହିନି
କିଛି କହିନି
କିଛି କହିନି
ଇଞ୍ଜେକ୍ସନ ସିରିଞ୍ଜ କଥା
ଟୋଟାଲି କିଛି ନାହିଁ ପେଷ୍ଟିସାଇଡ୍ସ କିଛି ନାହିଁ ଇଞ୍ଜେକ୍ସନ ସିରିଞ୍ଜ କିଛି ନାହିଁ ଯୋଉଥିପାଇଁ ତା threatening ଟା ଆସିଲା ବା ଯାହା subsequent part ମାଇଲା then my lord 6 my lord you have not deposed that accused Dasanto after completing administration of injection dealt lathi blows on both of your parents and sister accused Dasanto and Iru then unfastened the rope by means of which your sister was tied up. Then the accused persons instructed Damanto and accused Paranto to guard you and not to allow you to leave there, not to leave till their return. এটা ବି କହିନି ଆଜ୍ଞା ତ ବାନ୍ଧି ଦିଅ ବାନ୍ଧି ସାରିଲା ପରେ ବାଡାବାଡି କଲେ ଏବଂ ସେପଟେ ବି ନାହିଁ then 7 my lord this is also important my lord you have not deposed that accused Ajanta came with the gold neck chain of your sister ଫେରେଇଲା and gave the same to you after which he returned back to his previous location and both Damanta and Paranta threatened you taking not to disclose the incident before anyone otherwise they will kill you and rest of my siblings your siblings namely another sister and your 2 brothers ଆଜ୍ଞା ତ ଭାଇ ଏବଂ ୟାକୁ ମାରିଦବ ବୋଲି ସେପଟେ କହିନି ଆଜ୍ଞା ଟୋଟାଲି କିଛି ନାହିଁ they also threatened you to bring back your brother from the school on the pretext of sickness of your parents due to fever kill them on the way and will produce the knife with blood stain before you ଏପଟେ କହିନି ଆଜ୍ଞା ଯଦି କାହାକୁ କହିବୁ ତାହେଲେ ତ ଭାଇ ଭଉଣୀ ଆଣିକି ମାରିଦବୁ ବ୍ଲଡ ଷ୍ଟେନ୍ ଟା ଦେଖେଇବୁ ତାପରେ 10 to 15 minutes thereafter rest of the accused persons return back and call you to accompany them to take bath in the spring and return back home ତାକୁ ବି କହିନି as after killing human being they were not supposed to go straight to their homes without taking bath Damanta is not an accused in this case Paranto had not gone to the other spot as he was guarding you they insisted and forced you to take bath but you I'm sorry you did not agree and to take bath and after they took bath all returned back to your village as it was night time they asked you to not to return back home and take shelter in the house of any one of them you then slept in the house of accused Bubuna my lord ଆଜ୍ଞା ତାର 8 ଟା this is also important my lord you have not deposed that about half an hour of your stay in Bubuna's house accused Paranto Bubuna Dengu Ajanta came to you with cooked food of their house meant to be taken in dinner and asked you to accompany them to destroy the same by throwing in into the water from a breeze. As they apprehend them, apprehend that not taking dinner in the night might go to the notice of their family. Then they decided to convey a meeting in the next day, and thereafter all returned back, and you slept in the Bubuna house in the same night. Meeting ko thabi ratira previous night to disclosure that is also not there. Then, my lord, you have not deposed that in the morning accused Iru and Dasanta came and called you all to go to the meeting urgently, as they apprehended their villagers may get off early and notice about the occurrence. At that time,
meeting କଥା ତ ଅଛି
ଆଜ୍ଞା ମିଟିଂ ଏ ଯୋଉ କହିଲେ ସକାଳେ ଦଶନ୍ତ ଆମକୁ ଆସି ଡାକିଲେ ଏବଂ କହିଲେ ଯେ ଯଦି ନ ହବ ସକାଳୁ ଗାଁ ଲୋକ ଜାଣିବେ that part is not there.
ଓ ତାକୁ ଡାକିକି ନେଲେ
ଆଜ୍ଞା ସେ ପଟେ ନାହିଁ.
Okay.
Thereafter, my lord, at that time your paternal uncle Ghana came to you and you cried by holding him, but as they insisted to join them to go to the hilltop where meeting was organized, you accompanied them. Se jiba patta ke nahi. On the hilltop, your ward member Lagun Sabar, husband of Samiti member Darsingo Sabar, and other co-villagers were present, before whom accused person confessed that they had killed your parent and sister, as due to their witchcraft, two of your villagers had already expired.
Confession part 9.
Nah.
What are you saying?
Well,
Next day, village meeting was convened at the instance of ward member and the Samiti Sabya. The juvenile.
এটা খালি কেবল juvenile কই লাগে এমানে কিছু নয়.
All right. Yes, next.
My lord, confess that they had killed your parents and sister, as due to their witchcraft, two of your villagers had already expired, and their three other, namely such Gunguru, Bubuna, and Ajanta, are not getting relief from fever for many days. Being asked by the villagers, accused Dasanta admitted that he brought the pesticides from a shop about a week back, after he expressed his desire to the shopkeeper to purchase poison in order to kill pigs. This part is not there. They threatened you in the meeting that if you submit report to the police or give evidence in the court, it would not take second for them to kill you, and if they would be kept in jail, other villagers would not spare us. Because of their threat, considering danger to your life, you stayed in the house of Darsinga, husband of Panchayat Samiti member, from such and such to such and such date. It is not there.
ଏ ଯୋଉ 10 ରୁ 15 ଯାଏ ରହିଥିଲା ସେ
କିଛି
କଥା
କିଛି
ବି
ନାହିଁ. ସେ ଥ୍ରେଟିଂ ଟା ବି ନାହିଁ. ସେ ଯୋଉ ପୂର୍ବରୁ ଯୋଉ ଥ୍ରେଟିଂ କଲେ ସ୍ପେୟାର କରିବୁନି ଯଦି କାହାକୁ କହିବୁ.
Okay.
My lord, thereafter, my lord, 10. You have not deposed that on 16/9/2016 you came to know the accused person. My lord, may see 59 କହିଛି. 16/9/2016 you came to know that accused persons brought out the dead body of your parents and sister from the ditch where they had buried the bodies, and they set fire those by pouring kerosene on it on the preceding day. On one ditch was dug by JCB machine for a construction of a water tank, where it was learned they had buried the bodies. It is also not there. Hearing about this incident, you went to the police station and reported the matter at the police station.
Last question.
As deposed by you, 7, except the specific overtact of Jasanta Sabara, you have not seen any. You have not Jamsu Sabara. You have not made any specific overtact of any other accused person.
Jamsu Sabar କିଏ ସେ ଯୋଉ juvenile?
ଆଜ୍ଞା ତା ନାଁ ଯାହା କହିଛି.
Yes, anything you want.
No matter.
Bollywood आपको इसलिए handle होगी this short. IA number 1036 of 2024. This interim application has been filed under section 391 of CRPC by the appellants in CRLA number 750 of 2021. Under section 391 लिख ले, हाँ. For recalling informant, recalling PW1, Melita Savarna, comma, the informant for cross-examination, for further cross-examination on the questionnaire for the ends of justice. It is stated in the petition that PW1 was examined in city case number 7 of 2017 in the Court of London Additional Session Judge Gunpur on 31/7/2017. And after all the appellants were found guilty, and death sentence was imposed on them, they preferred DSREF 1 of 2018 before this court. And on 5/11/2019, jail criminal,
46 of 2008.
along with DSREF 1 of 2018, along with
Well, that was prepared by the state. We prepared jail criminal appeal 46 of 2018.
along with JCR numbers 1,
46 of 2018.
46
Okay.
of
Dear author,
2018, preferred by the appellant. The judgment was delivered on 5/11/2019, and the matter was remanded to operative portion. It is further stated that PW1 was examined before the Principal Magistrate Juvenile Justice Board Rayagada as PW12 in connection with the same occurrence in respect of the juvenile Karnataka as PW12 as PW12. And the evidence which she adduced before the JJ board was completely contrary to the evidence which he adduced as PW1. It is further stated that after remand of the case on 2/3/2020 even though PW1 was recalled and the Land Defense Council was given opportunity to cross-examine PW1, but the contradictions which are appearing in her evidence with reference to is evidence given as PW12 in GR case number 418 of 2016 could not be confronted. The Land Council submits that in the interest of justice, this court should exercise the power under section 391 of CRPC and allow the petition and permit the defense counsel to put the questions which are there in the questionnaire of the interim application to PW1. As per the order dated, the order that the objection हमने कोई से file किया आपने हाँ. As per the order dated 29/4/2024, the London Council for the State has received instruction from IIC Putta Singh Police Station dated 2/5/2024 that PW1 is now staying with her husband in village Tume Garjang under Sharang Police Station in the district of Gajpati. The written instruction is taken on record. The Land Council for the State has filed objection to the interim application, wherein it is highlighted that such a petition for recording additional evidence should be exercised when the party making such request was prevented from presenting the evidence in the trial court despite due diligence being exercised. And this power is to be exercised with great care and caution and not to fill up any gaps or lacuna of either of the parties. It is further stated that though it is submitted on behalf of the London Council for the appellants, that the evidence given by PW1 as PW12 in the before the Juvenile Justice Board was not within the knowledge of the London Defense Council, for which the same could not be confronted. But in the appeal memo appeal memo that you बाहर कर ले. In ground number
M.
ground number M,
Page 13 of
it is stated as follows: quote the entire ground. It is argued that in view of such ground taken, it cannot be said that the examination of PW1 as PW12 in GR case number 418 of 2018 was not within the knowledge of the Learned Defense Counsel, and therefore, after getting the opportunity, if they have not availed the same, no further opportunity is to be granted. The Learned Counsel for the state has placed reliance in the case of Rambhau and another versus State of Maharashtra reported in 2001 for SCC 759. Ajit Singh Chehulji Rathod versus State of Gujarat and another 2024 SCC online 77 SC 77. Purnachandra Samal versus State of Orissa and another 2017 SCC online Orissa 59. The use of expression previous statement in section 145 of the Evidence Act would mean and refer to the statement made by a witness earlier in time of his/her deposition in court. If that decision of that 74 criminal law journal. In the case of Brahmanaik versus Ram Kumar Agrawal, Honorable Justice G.K. Misra, Chief Justice आज then was, has held that the statement of the prosecution witnesses recorded by the predecessor assistant session judge are the former statements of the witnesses who were subsequently examined after the de novo trial, though in the same proceeding. These statements can be used for contradiction under section 145 of the Evidence Act. And the contention raised by the Learned Counsel for the petitioner that because there was a de novo trial, those statements must be treated as if non-existent or inadmissible, was held to be of no logic. In the case of Kali Prasad Das versus State, reported in AR 58 Calcutta 186, It is held that if the records of the previous trial are before the magistrate, there is nothing to prevent the parties to the proceeding from making use of the original records. Stop. As a matter of fact, in such cases only original record should be used. Stop. It is not necessary to require the party to produce the certified copies of the statement before the court. What is the decision that another decision 1999 for SCC 621? That is 1999 for SCC. 1999 volume 4. Take down and in the case of State of Kerala versus Babu, reported in 1999 for Supreme Court cases 6-1. It is held that any previous statement recorded during course of trial would be termed as a previous statement and can always be used for contradicting the witness or to prove omissions. In the case of Shantosh versus State of Chhattisgarh, reported in so and so, it is held that a previous statement of a witness recorded during the course of trial continues to be a previous statement, and in accordance with section 145 of the Evidence Act, the accused is entitled to contradict the maker of such statement with his previous statement. Stop. Since after the remand of the case, PW1 was examined on 2/3/2020 before the London Trial Court. The statement which she had given as PW12 on 14/11/2017 in GR case number 418 of 2018 during the inquiry of so and so before the JJ board can be taken as the previous statement. Therefore, it was legally permissible for the defense at their stage to confront the statement of PW1 recorded as PW12 on 14/11/2017 before the JJ board. However, the Learned Defense Counsel has not put any questions in that respect. The question that crops up for consideration as to whether the prayer for recall of PW1 to put the questions with respect to her evidence given as PW12 in GR case number 418 of 2018 is to be denied merely because the defense counsel did not brought such contradiction while cross-examining PW1 on 2/3/2020. In the case of Rambhau and another, bracket supra kar diyantu, the Honorable Court held as follows. Quote from paragraph number 2, 3, 4, 6. In the case of Ajit Singh Chehuji Rathod, comma, the Honorable Supreme Court held as follows. Quote paragraph number 9. In the case of Purnachandra Samal, this court held as follows. Quote paragraph number 11. After hearing the learned counsel for the respective parties and going through the ratio laid down in the aforesaid cases, we are of the view that in the interest of justice, to arrive at the just conclusion of the case, if additional evidence is required to be taken, which should not cause prejudice to any of the parties, the appellate court can take such evidence or direct it to be taken by the trial court. The question is of interest of justice, and particularly in this case, when the appellants have been sentenced to death and after going through the questionnaire, we feel it proper that an opportunity is to be provided to the learned defense counsel to put such questions in the cross-examination. Accordingly, the prayer is allowed. The trial court record ঠিক আছে, original trial court record. Okay. The trial court records, original trial court records, we sent to the London session judge from special judge Rayagada, the original case record in city case number 8 of 2020, sent so and so. And the London trial court shall issue summons to PW1 so and so, and allow the London Defense Council to put only the questions which have been mentioned in the questionnaire to this interim application. A copy of the interim application shall also be sent to the London trial court along with the trial court record. The London counsel for the upon produce karibe tanku witness that there should not be any delay because we have to fix the time limit.
Fix a date or they will?
No, we'll just fix that the entire exercise should be completed within this period. So in the meantime,
So direction is lower court may direct the IAC to produce. So I will inform that IAC.
okay, the
fix a date, any date convenient to this.
no, we cannot fix it. It
Yes,
will
madam.
depend upon. We will fix that within this period entire exercise. So
The record in appeal also is to be brought to the sessions court.
Yes, madam.
needless to say, needless to say that the original case records of GR case number 418 of 2018,
Same
which is,
station. Rayagada.
it's all right, but name it,
Yes.
which is pending in the court of who court?
Appeal ହେଇଯାଇଛି କେବଳ
No, no.
after the conviction.
ସେଇଆ କହୁଛି କୋଉଠି ଅଛି available ଅଛି original case
appellate
record.
court ଆଜ୍ଞା ସେଟା ଦେଇଥିଲେ ସେଟା
ସେଟା
ପିଛରେ
appeal court ଟା
ଆସିଛି and the report which has been the xerox copy, the top of xerox copy, the appeal number is there. ଆମକୁ ଦେଇଥିଲି
District Judge Rayagada.
appeal number ଅଛି
Acha, available in the court of London Additional Session Judge Rayagada in CRLA number 8 of 2018. Hala? Be called for.
Fourth additional district.
fourth and
Fourth
I don't know. Additional fourth national.
Additional. Be called for. And the land in order to avoid delay, the summons on the PW1 be served through the IAC, na? So and so co police station no set up.
Say Puttasing
police station. So कितने दिन
Month's time.
1 month. A month's time is granted. So he has to submit it. And
The evidence is recorded to certify and submit it to
after the evidence is recorded, the trial court shall certify the same to this court and fix a date after vacation. So the matter will be taken off
opening day.
the so let us keep it on 24th of June 2024. For the hearing.
Maybe if my lord can take it, direct the trial court to take the evidence on 18th. It can also be taken by this on 21st. On 18th, if my lord.
No, we are giving a month's time. Not that month's time will be over, obviously, but thereafter summer vacation.
Summer vacation start from.
So
before that also it can be taken up.
We'll send the record by tomorrow. maybe during course of the day it will be
Madam,
discussed.
madam.
Thereafter, you will do the needful.
Madam.
It is expected that the trial court shall record the evidence at any time before the ensuing summary. So,
A free copy of the
free copy of the order be handed over to the learned counsel for the state.
prosecution also be liberty to re-examine if necessary.
Prosecution should be let liberty to re-examine the witness if necessary.
If necessary.
Re-examine पुणी cross examine चल
ଆପଣ
I don't dispute that.
କହିବେ
But kindly see, if re-examination will be there, then sort of other
But
questions will be there.
ଆପଣ-
Then again, the meaning of
If
this
required,
additional
if
evidence will be
required,
frustrated.
necessary.
Re-examination may be required,
Yes.
may be required.
If the prosecutor know it is necessary, it may be they may get some clarification why such a statement has been made. So the prosecution is at liberty to re-examine the witness.
Well, in such a case, my humble submission, of course, Malad has limited the question to the questionnaire. Now, if the prosecution will come forward with specific other question, the difference
No question of other.
no,
It is only
no other. My humble submission, if the prosecution will be allowed for to recall the particular witness or re-examine the witness, in such a case, something will come up.
re-examination of scope both limited in view of that 100 to provision ଅନୁଯାୟୀ re-examination clarification ହୁଏତ ସେମାନେ ପଚାରି ପାରନ୍ତି ଯେ ତମେ ଯଦି ଏଇ କେସ ରେ 1 ନମ୍ବର ସାକ୍ଷୀ ହିସାବରେ ଏଇଆ କହିଲ ତାହେଲେ ଏଠି ଏମିତି କେମିତି
In case of re-examination, or it shall be duly considered by the learned.
it shall be duly
As per law.
considered
Right.
in accordance with law. ଇଏ ଆମକୁ ଆପଣ ମାନେ ଶୁଣି ପାରୁଛନ୍ତି ତ ଯୋଉ ଆପଣଙ୍କର ଆଡଭୋକେଟ ଯୋଉ ଦରଖାସ୍ତଟି ଦେଇଥିଲେ 1 ନମ୍ବର ସାକ୍ଷୀକୁ ଆଉ ଥରେ ଡକେଇକିନି କେତେ ଗୁଡାକ ପ୍ରଶ୍ନ ପଚାରିବା ପାଇଁ ଆଜି ସେ ଦରଖାସ୍ତର ବିଚାର ହେଲା ଏବଂ ଆପଣ ତାଙ୍କର ଦରଖାସ୍ତଟି ମଞ୍ଜୁର ହେଲା ତେଣୁ ଆମେ ଡାଇରେକ୍ସନ ଦେଇଛୁ ଯେ ସେ 1 ନମ୍ବର ସାକ୍ଷୀକୁ ଟ୍ରାଏଲ କୋର୍ଟ ଆଉ ଥରେ ସମନ କରିବେ ସମନ କରି ଯୋଉ ପ୍ରଶ୍ନ ପଚାରିବାକୁ ଦେଇଛନ୍ତି ସେ ଦରଖାସ୍ତରେ ସେଇ ପ୍ରଶ୍ନ ଆପଣଙ୍କର ଆଡଭୋକେଟକୁ ଅନୁମତି ଦିଆଯିବ କେବଳ ସେତିକି ପ୍ରଶ୍ନ ପଚାରିବେ ଏବଂ ତାପରେ ସରକାରୀ ଓକିଲ ଯଦି କିଛି ପ୍ରଶ୍ନ ପଚାରିବାକୁ ଚାହିଁବେ ପଚାରି ପାରିବେ ଏବଂ ମାସେ ଭିତରେ ୟାର କରିକିନି ରେକର୍ଡକୁ ପୁଣି ଏଠିକି ପଠେଇ ଦେବେ ଆଉ ଆପଣଙ୍କର ପରବର୍ତ୍ତୀ ଶୁଣାଣି ରହିଲା 24 ଜୁନ 2024 ତାରିଖ ଦିନ ହେଲା ଠିକ ଅଛି
ଆସନ୍ତା ମାସ 24
Another prayer also, Malad. Here also, as I have found, after the Malad argument was over, date was fixed to 21/10/2000 for the second time, 21/10/2021 for judgment. On the same day, hearing of sentence was there. On the same day, judgment was pronounced. Although as per the apex court judgment, the honorable court, at least in such a case where the court is proposing for death penalty, the court should adjourn.
Yesterday, madam.
pass the order. So let the matter come after so we can.
On that basis also. Same principle.
Same principle. Instead of a remand.
Yes, ma'am.
Better way we are passing the order on the interim application. Let that come.
Exactly.
Let it come.